So no PTI?
No PTI.
She knows about it, right?
Yes. Oh, I'm sorry.
Good morning, Ms. Hutcherson. It's Hutcherson. So you no interest in doing the PTI program?
She's currently in the PTI program. She's terminated.
Oh, she was removed? Oh,
I didn't have a.
got it. No, yeah, too late. Okay, so Ms. Hutcherson, you've worked out an agreement where they're offering you 3 days in jail, credit for the 1 day that you've done. You need to understand, ma'am, yeah, I just see that removed. You need to understand that this DWI will go on your record. It's going to be there for the rest of your life. You need to understand that if you ever get pulled over, an officer is going to look at your history. They're going to see this DWI. If you smell like alcohol or dope, it's not going to go well. You know, the other thing, what we're doing today, it's not going to, I mean, you're looking at a minimum of 30 days in jail from now on for whatever you pick up. So no more proverbial slaps on the wrist. You understand?
Here's the first major reality check. The judge is making sure she understands exactly what she's giving up by pleading guilty. Her right to a trial, to challenge witnesses, and potentially to appeal. And the warning about future consequences is crystal clear. This conviction stays on her record. But then comes the financial shocker, thousands of dollars in surcharges. Do you think the judge is being fair by laying out the long-term consequences this bluntly? Or is this exactly what defendants need to hear before entering a plea?
I bring home the.
I want you to understand something, ma'am, that, you know, DWI is big business. There's a $3,000 surcharge that usually is tacked on when you pick up a DWI. And when you get a second DWI, it's a $6,000 surcharge. And if you don't pay it, you go to jail for every $100 that you owe. You understand? I will waive your fees now. It's next time, it's around $7,000 you're going to be walking out. So if you want to get lit, just don't get into a car. $20 a button will take you anywhere you want to go. All right. Good luck.
Thank you, Judge.
Run it. Oh, I have to suspend your license. I'm suspending it for 180 days. You are Aziel Gracia.
Sir.
Mr. Gracia, so
He's charged with, I've never seen this before, Judge, but he's charged with violating a bond condition.
yeah, I mean, I've certainly seen it. It's
not a protective order, it's a bond condition.
right, because they can't make the protective order case because it's been more than 61 days,
Had
right?
nothing to do with the protective order, Judge.
So, yeah, right, I get it.
It was a different situation completely. Had nothing to do with family violence.
Get there. So you're charged in violation of a bond condition / protective order. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. If you cannot afford a lawyer will be appointed to represent you. So before we start, was he in a PTI? Is that why this case is 1,000 days old?
Yes, sir. He just has a few BIP classes left to finish the PTI.
Okay. Okay, go for it.
The officer was dispatched to a business in Harris County, Texas, in response to a disturbance. Upon arrival, the officer observed the defendant grab another male aggressively, and the officer conducted a search on the defendant's person and found a loaded gun in the front pocket. The defendant is currently on bond for an assault family violence and has bond conditions in place prohibiting from possessing a firearm.
Yeah, all right. Mr. Gracia, I'm going to find that there's probable cause to go forward on the bond conditions. State, what's your position as far as he's in a PTI? He's now picked up a new case. Mr. Gracia, I want you to know that we take these bond conditions extremely serious.
Sir.
You don't, though.
Okay, this is where the courtroom temperature goes way up. The judge isn't treating this as a simple technical violation. According to the court, the defendant was already under bond conditions restricting firearm possession. And now, prosecutors say he was found with a loaded gun. The defense argues he was protecting his business, but the judge is focused on something much bigger. If a court orders you not to possess a firearm, can you simply ignore that order because you believe the circumstances justify it? That question is now putting his bond and potentially his freedom in serious jeopardy.
He went inside, the individual started trying to damage the trucks. So at that point, he was fearful. He went and retrieved a firearm that he knew was hidden in the vehicle. I'm sorry, in there, I understand, Judge.
It's
And
about the worst thing that you can do. Imagine if you use the firearm. Who gets charged with murder? Mr. Gracia? Who has now dug themselves into a potential 50-year hole? We have a case like that today where a meager argument, someone who's charged with assault is now charged with murder because of a silly ass, stupid ass argument. Now dude is sitting in custody with a $250,000.
and he's been punished at this point, Judge. He's been punished for violating the bond by getting an entire new case on that. So as far as him going into custody for violating the bond condition, I would hope that you would take that into consideration, the fact that he has gotten punished on the bond violation already, and the fact that he's already had to hire a new attorney for two cases at this point, and it's probably going to affect the other case. So I would hope that you would continue supervision on that, just taking that into consideration.
I truly appreciate your position, but you have an assault from 2019 of a family member. The following year, you pick up a violation of a protective order or bond condition. Now you have another assault that they were even, what the hell you're looking over there? Was it Jesus over there? You already have an assault of a family member that was dismissed as it is. You were lucky enough to even have this kind of an agreement where they're willing to dismiss a second assault of a family member, and now you pick up another violation of a bond condition. Eric, he doesn't get it.
I understand, Judge.
You don't get it. And now I have to show you we mean business. I think that you are utter and complete danger to public safety. And I will do everything in my power to protect my public in every single way. Because the last thing I want is you to pick up a murder case like we have here this morning. Someone else goes with you.
Judge, one more thing. There's a bond condition on there that he's not allowed to return to that address. That address is his business. It's his place of business. The other person has no right to that address. So hasn't worked for the last week and a half because there's a bond condition, I'm assuming from the magistrate, that doesn't allow him to go back to that business.
Show me proof.
I'd like to be
Show
able
me
to take
proof. And, the proper, and you need advice. The proper way to do things is you call the cops.
that.
Really. I mean, that's, if you own the business, you show it. I mean, how easy would it have been to just call police?
I mean, he has a right to defend his property and.
Not while the case is open. He does, but not in that manner.
It's one of those things where things happen quick and you have to make a decision. And when we're talking about trucks that are worth hundreds of thousands of dollars and things like that.
911, man. Really?
How long do they take to get there, Judge? So
Okay. They will still take his ass to jail and then, try to get restitution or whatnot. But
So as far as the bond goes, can you set him a bond today?
Of course.
And Judge, we've contacted Conrad because it's his case, but I just want to confirm that bond's been revoked for his prior case. Is that correct?
yeah,
Okay.
yeah. On the assault, I'm revoking it.
Yes, Judge.
Looks like they set the bond at 20,000 on the new case.
Yes, Judge.
I'm gonna mirror it.
Because he's already posted that bond, he's already hired me. He hired me on the other case as well. There's a motion to sub in your queue that I need you to sign as well.
I'll sign it for you.
I'd ask that you set that new bond at $500. It's tough for the family, Judge. I mean, at this point, he hasn't worked in 2 weeks. He's trying to get back on his feet. He did everything properly. He didn't go back to the location because of the bond condition.
I'm not doing $500. I mean, I was thinking that was gonna mirror the same one. I was gonna put it at
And that would be
20,000.
state's position to mirror.
So he understands that we mean business, if he's unable to bond out, I'm always willing to talk after a couple days, but I want him to understand that.
And there's the judge's final message. This isn't about revenge, it's about consequences. The court is clearly trying to send a signal that bond conditions are not suggestions, especially when a firearm is involved. The judge ultimately sets the new bond at $20,000 instead of the defense requested $500, while leaving the door open for another conversation after a few days. So what do you think? Was $20,000 a necessary wake-up call, or should the court have considered the defendant's argument that he was protecting his own business?